What to expect on your first day in court when sued for debt. Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. If you're being sued for debt, you probably got what's called a summons telling you to respond to the attached petition and go to court on a certain date and time. Answering the petition is not hard. It's actually easy. But then what? Do you still have to go to court? And what happens when you do? Once you answer the petition, you should not be defaulted no matter what happens. That's the theory. But the practical reality is that even if you file an answer but don't show up at court, your case may be defaulted anyway. You could probably get that default vacated or set aside pretty easily, but it's a needless risk and it's trouble. Instead, once you've answered the petition, you're in a much better position in terms of asking the court or the other side for a continuance, some sort of a delay, if it's not convenient for you to be in court on the date that's scheduled. Filing an answer raises your status in court dramatically, and remember, it's easy to do. When you go to court, what you're likely to encounter in court on that first day is a sort of crazy scene. In any big city, there are likely to be hundreds of people milling around in the courtroom. And if you're in one of the lower courts, like an associate circuit court, there may be several hundred cases on the docket, that's the court calendar, for the day that you're in there. It could take the court a couple of hours for the court to call through all the names, and you need to be present to hear your name called so that you can announce your presence. Beyond that, usually nothing of real importance happens on that first day. If you don't show up, the case will be defaulted. If you do show up, however, the case may very well be continued, that's postponed, to another date about a month later, and nothing at all is done on the first day. That's often true. Sometimes, however, the courts want to set up a calendar schedule for the rest of the case, and you should prepare for this possibility. The court may want to set deadlines by which the parties must finish with their discovery, file any motions, and even set the date for a trial. In some jurisdictions, they might assign your case to a different courtroom. The main thing is you don't have to worry about having the trial or making any important arguments on that first date. You don't have to know that much. It's an administrative day. And if you go there, there's not going to be a decision made on that day. I usually suggest that pro se defendants serve a first round of discovery, that's formal request for information for the other side, on the debt collector along with their answer. That's because, again, this raises your status with the court dramatically, and it means that you can insist on an appropriate amount of time for the preparation of the case in the scheduling hearing. Right? They could have that scheduling hearing the very first day that you go in there. You want to be in a position to insist on getting enough time to prepare for the case. In general, pro se or any defendants in debt law cases want as much time as possible for discovery to take place, whereas both the plaintiff and the judge will normally push for less preparation time. As the defendant in a debt law case, in general, you want enough time to 1. File the first round of discovery. 2. Allow them the time they need to respond to it. 3. Give time to haggle over what they didn't provide in their responses. 4. File a motion to compel. And 5. Give the court time to hear and rule on the motion to compel. In practical reality, this is going to take at least 4 months. If you also want enough time to file a second round of discovery and then file a motion, like a motion for summary judgment, that uses what you've found in discovery, you're going to need at least another 4 months. And that means you want the court to set a trial date about 8 or 9 months away from that first date. Since a debt collector isn't used to doing anything more difficult than collecting default judgments, and since the court has deadlines, both of them will be leaning on you to compromise the time away. You will be in a much better position to negotiate if you've already served your first round of discovery on them. On the other hand, since the plaintiff likely can't get the documents it needs in less than a few months, you might prefer to press forward and try to get a court date as quickly as possible. I generally like to have more time, but if you prefer to push it forward, then you'll be in better shape to do that too if you've already served that first round of discovery. Just remember that you can't get completely ready in less than 4 months. That's pretty sure. You need that much time to prove they don't have the evidence that they need. Protect what's yours and don't let the debt collectors rip you off. My site and materials can help. Go to yourlegallagup.com. Get my litigation manual and forums, or get the videos and defend yourself. You'll be glad that you did. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallagup.com. Get my litigation manual and forums. If you appreciate this video, please take a second and like it, subscribe, and friend me, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors. On Facebook or YouTube, as these things help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.